we were to withdraw from the VFA? And my quick answer is this has been answered by the Supreme Court in the case of Salonga versus Executive Secretary, where I was both a petitioner and counsel for the former Senate President Jovito Salonga. In brief, the court was very explicit. It said that the VFA was constitutional because it was an implementing agreement nonetheless upheld our contention that the Romulo-Kearney agreement was in fact illegal as being contrary to the provisions of the VFA itself. Now, of course, the ruling of the Supreme Court that it is a mere implementing agreement is very important because we know that the language of the Constitution is that only treaties must be concurred in by the Senate. And the Supreme Court was very clear. It may not have been a treaty. It is an ordinary implementing agreement. And this was the court's way of addressing a lacune that its earlier ruling in the case of Bayan versus Zamora had. No? Because in Bayan versus Zamora, they did not squarely address, is this a treaty or an agreement? They merely said, whatever it is recognized as an international agreement by both the Philippine government and the U.S. government. And so they had, on the second occasion, where the same issue was brought to the court, they needed to address that particular issue of, is this the VFA a treaty or not?
But,
and yes,
Professor Roque,
yes, Your Honor.
There was no ruling as to whether or not the president can unilaterally terminate a treaty, because that was not an issue there. It was an issue as to whether or not the VFA is a treaty or an executive agreement.
Well, I beg to disagree. In fact, that was what I said in oral argument.
Exactly.
In oral argument in the court, I revived the issue of the fact that there are two provisions in the Constitution relative to Senate concurrence. One is a general rule, which is Article 721, that no treaty shall be valid and binding until concurred in by the two-thirds vote of the Senate. And another is 28, Section 25, which says that where we're talking of foreign troops and bases, then it has to be in the form of a treaty duly recognized by the other contracting party as such. And we brought up the issue again of whether or not the VFA, since it was not concurred in by the U.S. Senate, was in fact a treaty which was required to be entered into for purposes of 25 of Article 8, Section 25. And the court said it was not one. And that was why the court had to say it's a mere implementing agreement. So because this was already the second time it was brought to the court had to address that issue precisely and say that it does not require concurrence because it's an implementing agreement of a treaty, and the treaty that was duly ratified by the U.S. and the Philippine Senate was the mutual defense.
Because it was not a treaty. But nothing in that case said that the concurrence of the Senate is not necessary in determination.
Well, because the Constitution does not provide that Senate concurrence, Your Honor, is required whenever we are to withdraw from a treaty.
Yes, precisely. That's the legal issue that we are now debating. And the proposed Senate resolution expresses the sense of the Senate that the concurrence of the Senate in the withdrawal is needed because of the principle that the process of ratification and the process of withdrawal should reflect the process of ratification.
But it is my humble submission, Your Honor, that this may be an instance of Senate overreach. Why? Because in the very recent case of the Intellectual Property Association versus Executive Secretary, the court in fact said that it was actually the DFA that will determine whether or not an agreement is a treaty that would require Senate concurrence or whether or not it is a mere international agreement. And this is still pursuant to Commissioner of Customs versus Eastern Trading, defining what a treaty is, one which formulates a new national policy, whereas an agreement fills in the details of an existing national policy.
These are distinctions between an agreement and a treaty, but it has nothing to do with the power of the Senate to concur, to require the approval of the Senate in the withdrawal from the treaty. In fact, that's an open question as we debate on it today. And the 305 proposes to put across the sense of the Senate that the withdrawal from treaties would require Senate approval, and that is why we will be asking the Supreme Court to rule on this issue.
Your Honor, again, let me clarify my position. No? Perhaps the reasoning why some senators believe that Senate concurrence is necessary in any instrument that they have concurred in is because the Constitution says before it can be valid and binding, Senate concurrence is needed. This is a requirement, sine qua non, for a treaty to become more or less part of domestic law. But you see, it is not actually the process of legislation. It is only said to be a requirement for a treaty to become valid and binding. It is still not the same as a law enacted by Congress. Why? Because if it were to be exactly a law as enacted by Congress, then the House should have participated in it. The fact that the framers of the Constitution limited the role of the Senate in concurrence in order that a treaty can become valid and binding means that the role of the Senate in this regard is limited to ensuring that as a co-equal branch of government, it functions or it discharges its function to be, a co-equal branch in the exercise of equality of powers between different branches of government. No? The fact that it has not required concurrence also for withdrawal is a recognition that whether or not a treaty continues to serve the national interest is an issue now vested with the chief executive, the executive department.
Yes, Mr. Chair. May I, for the benefit of the body, just remind ourselves of the prior concurring opinion in IPAC.
Yes.
Which Attorney Roque referred to. Without doubt, the President has the sole authority over the conduct of foreign affairs, and this includes negotiation, ratification, and so on of internal agreements. This is the crux. The President has full discretion, subject only to the limits found in the Constitution. Hence, when you have a lacuna legis, as is clearly the case regarding the abrogation concurrence requirement, I think that, like Attorney Roque, there is no limitation imposed by the Constitution, and hence there is no requirement for Senate concurrence. This, by the way, is the most recent jurisprudence, having come out only in July 19 of 2016, so it supersedes the past, GR number 204605, if you care to keep the citation.
Any other comments? Senator Gordon? Or done?
Friendly regulation.
Sorry, you were raising your hand.
I was beginning to feel forlorn. Let me just ask the body, if I may. The resolution filed by Senator Dilawan a couple of years ago, several years ago, on the matter of all treaties requiring congressional Senate ratification, and if there is going to be an abrogation, wouldn't that be considered as a very clear signal already to the Supreme Court that such a thing has not been opposed, has not been contradicted? Would that be a clear signal to the court already? Is Dean Santa Maria?
I don't believe so, Your Honor.
Because, as I said preliminary in my statement, there is such a thing as an abuse of right. It's not the right itself, but the manner by which that right is exercised, which can be questioned. And that's why we have the extraordinary powers of the Supreme Court in the Constitution, that any one of us can question any act of any agency or instrumentality of the government, even of this Senate, if there is grave abuse of discretion.
Correct.
And even the act of the President itself. So, precedents will come in and out, but precedents can always be questioned, because precedents can be wrong. And that's why the sense of the Senate is so important, because this is a body that has weight, whose statement can carry the greatest weight in terms of treaty making.
And that is precisely part of the legislative powers of the Supreme Court. Would you say so?
Yes.
When they interpret and set new precedents?
Well, yeah, in a way, yes. Because, but when you come out with precedent, when you look at the law and when you look at limitations, it is not only express limitations that may be involved. there may be implied limitations granted by the law. And the Supreme Court should be able to discern this. That's why we have new jurisprudence like what I said a while ago. It can come out and the Supreme Court can apply it.
You're saying nothing is cast in stone depending on the circumstances of the future or the present tense.
You know, the law is a dynamic thing.
Says it.
It cannot be frozen in time. And that's why we have the concept of due process. And whereas before we only thought of due process, substantial due process, and it developed, and we have now the procedural due process. So it will develop. It will, and this is the right time for it. Whether or not, by clear implication of the law, the right to conclude a treaty, which includes the Senate, carries with it the right to participate in its abrogation.
But it is obvious that I believe that the concurrence of the Senate is required and that it is a law. And I disagree with my good friend Attorney Roque over there, that a treaty is a law. It may not go through Congress, but it takes the form of a special legal animal because it's provided by the Constitution that it becomes a law under the Declaration of Principles that we adhere to internationally accepted principles of international law as part of the law of the land.
And one more point. The Constitution provides treaties and international agreement, a very generic phrase.
Precisely.
So it might literally include almost all agreements of the Philippines with another state. So it does not limit, the two-third vote is not limited only to treaties. The Constitution clearly provides and other international agreements.
As I said, in the course of the deliberations here, I'm not closing the idea that we can propose revisions of the agreement should the President change his mind. But of course, the President would have to change his mind, and I don't think right now he's disposed to do that.
You know, Mr. Chairman and honorable senators, in ordinary contract law, if there is an ambiguity in a provision, what are the tools for its interpretation? One way is to look at the contemporaneous and subsequent acts of the parties. And one of the and we have that subsequent act, as Senator Dilawan was pointing out. Subsequent acts in subsequent treaties, Senate providing for, if this will be abrogated, then you will have to get concurrence. And that could not, and that may not only be a sense of the Senate, but the actual interpretation of the law.
Which was my point in my first question in this round, that there is no abuse of right on the part of the Senate to assert that all treaties and agreements must be ratified, not only ratified, but will be subject to scrutiny by the Senate if it is abrogated.
Of course, yes. No abuse of right at all by the Senate.
Because you interpret that. I thought you were referring to the abuse of right by the executive when he unilaterally declared it without...
well, abuse of right can go both ways.
Yes, of course.
Okay, can go both ways. In this particular case, I personally feel that there might be, or there's a great sense that there is an abuse of right. That's why in my statement, I premised the 1991 abrogation of the U.S. military bases. It was deliberately done. There were discussions. There were public debates. We were all involved. And so at the end point, the denouement is its termination. And we feel comforted by it simply because people who want to end it were rational and very deliberative. But unlike in this case, had it not for the cancellation of the visa of Senator De La Rosa, with all due respect, this issue probably wouldn't have come out. That's a problem.
And that was precisely my point when I referred to Senator Tata's point earlier on the manner upon which the abrogation occurred. And are these valid reasons, or are this whim, caprice, pique, anger, which is temporary, or, I don't think it has any place, for example, with all due respect, to international negotiations or agreements. That is my only point.
Yeah.
Not to insult anybody,
Yes.
but to make sure that we are on course, that foreign agreements, treaties, laws, they must be done with cerebral certainty.
That is correct. That is correct, not by whim, not by caprice, and not by a spur of the moment or knee-jerk reaction. It must be a deliberative process that might probably take 2, 3, 4 months. Because it involves serious, substantial interest involving the country.
And I think that is the crux of why we are here today. Thank you.
Senator Marcos?
Mr. Chair, yes. May I just make a point of clarification, Dean Santa Maria?
Yes,
You
Your Honor.
have repeatedly said that the right may be clear, but the right may be abused.
That is correct.
Are you saying, therefore, that President Duterte has the right to abrogate the treaty without the concurrence of the Senate, but he has somehow, by impetuousness, by impulse, by caprice and whim, exercised it in an abusive way?
Okay. I hope you don't misinterpret me. Because going beyond the jurisdiction of one's power, there is a penumbra or shadow that every nuance of that abuse may come in. One is absolutely no jurisdiction at all. It is my position that that is the point. But even assuming that he has it, then there is an abuse. So I do not think that each one contradict each other. That's just my point.
So are you conceding that the President has the power to abrogate the treaty
I just told you,
without
Mr.
the Senate?
I just told you, Madam
I'm
Senator.
just reiterating, I'm a little bit unclear po.
No. I am just saying that it is not mutually exclusive. Each one may come in within the penumbra on unauthorized action. I hope you get me.
Okay, we leave it at that for now, but it's not entirely
We will-
convincing po. Sorry.
We will just reread the transcript and try to add. I have a question to ASEC Bailen. Hypothetical lang, Philippines has bilateral treaty with country X. Country X communicates its desire to terminate its treaty with us. So, whose word do we trust that country X is now terminating its treaty with us? And then do we examine the compliance with the constitutional processes in country X before we also accept their communication that they want to terminate?
Thank you, Mr. Chair. Generally, we will look into the provisions of the bilateral agreement with country X if it complies with the termination or withdrawal of the treaty. Otherwise, we can also take a look at the relevant provisions of the Vienna Convention on the Law of Treaties. So it would be their foreign ministry, normally under the Vienna Convention, and in specific treaties that would be authorized to send the termination of the agreement as the DFA has done with respect to the BFA. And we normally would not look beyond the reason for that termination, but just whether or not legally complies with the termination requirements.
Yeah.
Senator Dilawan.
ASEC Bailen, in the course of your presentation, you said that the power to enter into a treaty is with the President, and therefore the power to terminate should also with the President. First question, is it the power to have a binding treaty shared between the President and the Senate through the ratification, concurrence of the ratification process?
Yes, Your Honor.
If it is shared in that aspect, shouldn't it be a shared power also in the withdrawal?
In treaty making, Your Honor, the Constitution is expressed, but in the President's decision to withdraw, it is not.
Yes.
And therefore, our position is that it cannot be implied.
All right. All right. Now, I'll ask you a very specific question. Under your theory, the President can unilaterally withdraw from the Treaty on the Law of the Sea.
Yes. Yes. Yes.
Theoretically, yes.
Theoretically, yes. Why theoretically? Why? And what will happen to our assertion on the 200 economic zone?
Your Honor, the exclusive economic, even theoretically, with the President to withdraw the Philippines from the 1982 UNCLOS,
Yes.
with respect to the specific question of the exclusive economic zone, the exclusive economic zone, that's part of customary international law under Article 38, Paragraph 1D of the Statute of the International Court of Justice. So, customary rights and duties for the Philippines exist with respect to the EZ.
But what is critical is that this is a policy issue which a policy-making body like Congress should participate in, because you cannot deny that a termination of the treaty such as UNCLOS, such as ASEAN, has very wide-ranging consequences, and it cannot be left to one man, no matter how brilliant he was or he is. It is a policy issue which two political bodies of this government must participate in, especially that the Congress is a policy-making body, and the termination of a treaty would have very serious policy consequences. Would you agree with that?
Your Honor, I would agree on the first point on the gravity, seriousness of the issue. But with respect to the specific question in the committee right now on whether or not the President could withdraw, we would stick to our position, of course, that the President can do so absent.
Understandable, Mr. President.
Thank you. So, Attorney Roque?
Yes, well, I'd like to speak now as a professor of international law. There are matters, in fact,
That is why you were invited.
yes, there are matters, in fact, where neither the Senate nor the President can withdraw from. And these are customary norms of international law. There are some treaties that restate customary norms, for instance, the prohibition on genocide. And even if the President were to withdraw and the Senate were to concur, that would not be binding on us, because customary norms are binding whether or not we agree to be bound thereto. Now, on the specific issue of a formal treaty recognized as such, whether or not the Senate could concur in, that exact same issue now is pending before the court. And this has to do with the withdrawal of the President from the Rome Statute of the ICC.
I am a petitioner.
Now, that is in fact, it would in fact be a superfluous issue if the Senate now were to bring the same issue as far as the VFAs is concerned. And that is why in my earlier intervention, I had to distinguish that the VFA, according to the Supreme Court, was not a treaty, a mere international agreement, but the issue on withdrawal from the Rome Statute of the ICC will now determine whether or not the Senate concurrence is required.
We will not bring the BFA. It's an issue of a definition and delineation of constitutional power insofar as abrogation of treaties is concerned, not at the BFA.
Correct. But you see, oral arguments have already been had on the withdrawal of the country from the Rome Statute of the ICC. And from the interpellations of the justices, it's very clear. There appears to be a consensus amongst the justices where the Constitution is silent, it cannot be implied. And therefore, although the court still has to issue its decision, as far as the Rome Statute of ICC is concerned, that seems to be the consensus on the basis of oral argument. And I did watch the oral arguments online because it's now broadcasted online. No? It is by the Supreme Court. No? And of course, we have to deal with constitutional commitments. No? When the Constitution requires concurrence, it will expressly provide for concurrence. And if it does not provide for concurrence, that means it is not a requirement. Now, I think also one last point is that it is only under Philippine law that we make a distinction between treaties, international agreements. Because under the Vienna Convention on the law of treaties, it does not matter what you call it. For as long as the three elements of a treaty are present, then it is a treaty. But we make a distinction precisely because of the two provisions in our Constitution that when it comes to stationing foreign troops and bases, then it can only be allowed in the form of a true treaty duly recognized by the other contracting party as such. But this distinction does not exist under international law for as long as the three elements are concerned. So now we're talking actually not of an issue of international law, but an issue of constitutional law. Thank you, Mr. Chairman.
Thank you. So, we will serve lunch, but we can now